Keying into the Renew Hope agenda of the present administration, the Ministry of Justice embarked on several judicial reforms to make the administration of the criminal justice more efficient and effective. The Attorney General and Minister of Justice Lateef Fagbemi, Senior Advocate of Nigeria, realizing that many of the subnational governments are culpable of being involved in financial crime simply because they indulge in the management of local government funds, approached the Supreme Court to get the financial autonomy for the local government.
He has created a platform, an enabling environment for the Ministry of Justice and the private sector, the civil society, to work together. That's commendable. I also salute his effort at local government reform. For me, if that can work, it's going to make a lot of positive impact.
It is only somebody who has faced those challenges in criminal trials from state to state as they differ that will understand they need to harmonize and have a uniform system operating all over Nigeria, all over the courts, so that what you get in the court in Abuja is not different from what you get in the court in Sokoto, so that what you get in Sokoto is not different from what you get in Port Harcourt.
Not relenting in its effort to fight corruption, the anti-graft agency EFCC has continued to prosecute those investigated and alleged to have committed financial crimes. Prominent among people with financial crime cases before the courts in 2024 include the former governor of Central Bank of Nigeria, Godwin Emefiele, who is still facing trial in multiple courts with varying counts bordering on alleged embezzlement, misappropriation, and money laundering. The case of former governor of Kogi State, Yahaya Bello, is also before the Federal High Court and the High Court of the FCT on alleged financial crimes amounting to 110 billion naira. While he was denied bail by the High Court of the FCT, the Federal High Court granted him bail with a sum of 500 million naira with two sureties who must have landed property within the jurisdiction of the court. A former Minister of Aviation under the administration of President Muhammad Buhari, Hadi Abubakar Shirika, and his brother were arraigned before Justice Begori of the High Court Garuki. They were arraigned on 10 count charge bordering on contract fraud to the tune of 5.8 billion naira, which they pleaded not guilty. They were subsequently granted bail with a sum of 100 million naira each with two sureties.
There are cases that have gone on for the past 6, 7 years, and there's no the date when they might be concluded is not in sight. Even when you conclude the trial, they can go on appeal. But plea bargaining gives you a certain closure within a limited period of time.
Another criminal trial before the court was that instituted against Binance Nigeria. But in October 23rd, the Nigerian Anti-Corruption Agency dropped a money laundering case against the top cryptocurrency executive, Tigran Gambaryan. The Nigerian government had accused Binance of manipulating the local currency through peer-to-peer trading on its platform. It subsequently slammed tax evasion, currency speculation, and money laundering counts to the tune of $34 million against its executives. There were other cases of cyber crimes that took place in 2024. Commenting on how the courts have fared in handling criminal cases, legal experts say it was challenging. But with the ongoing reforms under the Renew Hope agenda, they said things are getting better.
We need to reduce the number of times that witnesses are physically needed to come to court. We need to come up with a system where testimonies can be taken without them physically being in court.
We have common, similar minimum standards. In other words, everywhere you go in Nigeria, you can expect that you will find these provisions there. That's one.
To expedite criminal trials, they have this suggestion for the critical stakeholders in the justice sector.
I think apart from the judges, apart from the investigators, apart from the prosecutors, it is important that the authorities, the NJC particularly, to set a deadline for e-recording to become the normal practice in our courts.
They express optimism that 2025 will be better going by the reforms embarked upon by the Ministry of Justice. In Abuja, Austin Anyebe, NT News.